Hi, everybody. We have a number of people that are still entering the waiting room, so we're going to just give it a few seconds for everybody to be admitted before we begin.
I asked him, he's like, yeah, no, I never had a cough, nothing. I just had a slight fever. But now he's got to wear one of those heart monitor things. They got to take through his chest.
If everybody could mute themselves, that would be wonderful.
This afternoon, and I think for tomorrow as well. Let's take you online though to Lake Michigan.
And if not, I'll go through and mute all of you for you.
I wasn't sick. And the guy starts mowing the lawn at 7:15. I was right outside the window. So
Judge Maloney, if you could unmute yourself, I know you have someone helping you on the tech side of things, but if you could unmute yourself and Judge.
I thought I accomplished that, but maybe not.
Okay, you have now, Judge. Thank you.
Okay.
All right, so we still have some people coming in, but I'm going to go ahead and get started. It's 12:03 at this point. I will continue letting people in. We're here today for the December speaker series for the Kalamazoo County Bar Association. We teamed up with the West Michigan chapter of the Federal Bar Association to bring you this presentation. It's a really good one, you guys. We have a number of great speakers. We have U.S. District Judge Paul Maloney, who's present with us today. We have Michigan Court of Appeals Judge Thomas Cameron and Kalamazoo County Assistant Prosecutor Heather Bergman. These individuals are all going to provide us a lot of insight on speaking persuasively, writing persuasively, and kind of talking on certain topics that all of them deal with on a very regular basis. Normally we do a little bit longer of an introduction, but with the great content that I think we're going to be able to get, we'd like to just get going. And we're going to start with Judge Maloney, who's going to talk with us about professionalism and candor with the court. And I'm going to go ahead and turn this over to Judge Maloney now. And again, I think I asked at the outset, but I think there are a lot more people in here at this point. If everyone can please make sure that you stay muted so we can hear the content that they're providing, we would appreciate it. And we'll turn it over to you, Judge Maloney. Thank you.
Thank you very much. And it's a pleasure to be here on this Zoom meeting. Obviously, live and in person would be preferable, but given the circumstances, Zoom is the best we can do. But I'm glad to join Judge Cameron and Assistant Prosecutor Bergman in this presentation. I've been asked to first address candor with the tribunal, candor with the court, and professionalism in presentations to the court. The first general observation I would make is from a judicial standpoint, every lawyer who makes a presentation either in writing or orally before the court, or in these days on Zoom or telephone, is building a reputation with the bench. Every pleading that you file, every oral argument that you make in front of the court is building a reputation with each judge that you appear in front of for professionalism and candor with the tribunal. And over my time as a state judge and a federal judge, fortunately in Western Michigan, I haven't run into too many problematic lawyers in this regard. This is in great contrast with some of my discussions with fellow federal judges in other districts in the Sixth Circuit. But for the most part in Western Michigan, I've been very pleased with the candor of the lawyers and the presentations that are made in front of me in terms of deciding legal issues that are in front of me. Judge Cameron is going to be dealing with the nuts and bolts of effective brief writing and oral presentations, but from the context of candor with the court and professionalism, I thought I'd comment on a couple of things. It's obvious first, but be truthful in your factual recitation and your legal argument. Don't mislead. I am concerned from time to time about factual assertions that may be literally true but are misleading, and that is of some concern to me. And bear in mind that if you do either, you're probably going to be spending a significant amount of time on oral argument, if you're given oral argument, explaining the unexplainable, if indeed you have misrepresented something to the court in terms of the factual background, especially of the court. Secondly, in terms of presentation of legal argument, it's accuracy of the citations goes without saying when you're making your presentation, either in writing or orally. But one of the points that I'd like to make is dealing with contrary authority to your legal position. This is sometimes a frustration for me in that there are obvious cases out there that may not be in support of a particular lawyer's position, and they're not dealt with either in writing or during the course of initial presentation of oral argument. And I think it's much more effective, not only from a standpoint of prevailing in your case, but also in terms of building up the reputation with the court in a positive way. It's much more effective to try to deal with the contrary authority to your legal position in writing first, and then be prepared to deal with it at oral argument. And I think the best, most effective way to do this on the candor with the tribunal front is to deal with it directly. Address it directly. Do your best, obviously, to distinguish the case law that is not helpful to your legal position, but deal with it directly. And from time to time, when I'm faced with these situations where contrary authority has not been given to me, I use it as a test with the lawyer. I'm not only testing the legal argument, but I'm also testing the candor of the attorney. And I will ask the lawyer, when Smith versus Jones does not support their position, I'll ask directly, how do you deal with Smith versus Jones? And you need to be prepared with that, and you need to do the best you can to distinguish it. The worst thing you can do in terms of building up your reputation is to try to do a blanket denial that the case doesn't support your opponent's position. If I wouldn't be asking the question unless I thought that there was a reasonable expectation that this case was helpful to one side or the other, I'm giving opposing counsel the opportunity to comment, but blowing it off is not the best way to handle it. Finally, in terms of decorum in the courtroom, if you're not familiar with the judge's rules, if you will, of the road, ask the staff. Call my staff. Will Judge Maloney allow us to move around the courtroom? One of my former colleagues had a reputation for telling lawyers to stay at the podium. Don't move from the podium. If you move from the podium, that's not good. You're going to get called on it. That's not my rule, but to the extent that you have some concerns about what the rules of the road are in a particular courtroom, try to get that information from the judge's staff. In the advent of Zoom, Decorum on Zoom, I'm told, I haven't experienced this personally, but decorum on Zoom is becoming an issue. I've talked to some state judges who have had bad experiences with lawyers on Zoom. I heard one instance where a lawyer was vaping during the argument on Zoom. Yeah, I see your reaction. For those who are on camera. And then I've also heard anecdotal information from state judges about lawyers whose clothing is totally inappropriate to be appearing on camera in front of a judge. So that's anecdotal information. I have not experienced it myself. But to the extent that decorum on Zoom is becoming an issue with lawyers, I thought I'd point that out. 2 quick points on pet peeves. Don't attack opposing counsel, either in writing or orally in court. That's a turnoff for me personally, to make personal attacks on a opposing lawyer in their brief. So I would not, don't do that. And petty again, and I don't see much of this either in the western side of the state. Petty bickering is also not particularly helpful as well. Be on time. You don't want judges talking amongst themselves when they're talking about particular lawyers that, that lawyer shows up on standard Smith time or standard Jones time, which is usually 15 or 20 minutes after the scheduled argument was scheduled to begin. Again, not a problem that I've run into much, but being on time is a particular issue. I try to be on time. Sometimes I miss it, but being on time with the tribunal, I think, is also extremely important. So with that, I'll stop. And Jennifer, where do we go from here?
Thank you, Judge. I don't see any questions. I did send something out in the chat indicating that if anyone has any questions during each topic, you can email them to me. My email is in the chat, but it's jlafond@hillslawoffice.com. It looks like we just got one from Chris Tracy for you, Judge Maloney. Can you give us a sense of what trial and hearing practice before you or your colleagues in the Western District will look like for the first quarter in 2021?
On the civil side of the court, I don't see any prospect that will be doing anything but Zoom or giving you the option to do anything but Zoom for the first quarter of the year. I am perfectly happy with, if you want to come to court, that's fine with me. I don't know what my colleagues are doing. Some of my colleagues might be doing just Zoom. But if you want the option of Zoom, just ask. And we will, and I will accommodate. I think in the first quarter of the year, that's probably going to be a continuation situation in our court. Our court has not gone to Zoom on major items such as guilty pleas, sentencings. All our judges are still doing in court, and I don't see a prospect that will change that. I had a request from a lawyer to appear by Zoom with his client for a sentencing. Our administrative order does not allow that, and I don't see the prospect that we're going to change that. So criminal proceedings, as far as guilty pleas and sentencings are concerned, will continue to be in court.
Thank you, Judge. And John Allen, it looks like you have a question, and I don't know if you want to ask it out loud, if you want to go ahead and unmute yourself.
Sure, I'll do that. First of all, Your Honor, thank you very much for taking the time with us today. These are always valuable insights for practitioners. My question is about a question, and that is, how best to respond to a question by the court. And I guess I would also add a former colleague of yours on this court, now on the Sixth Circuit, had his own informal rule that when he asked a question, the first word out of your mouth had to be either yes or no. He would give you a chance to explain, but I'm wondering what your view is and what you think the best approach is on that. Thank you.
I wonder what former district judge you're referring to, John. It's really good to see you, John. We haven't crossed paths in quite a while. It's great to see you.
Well, you've been very busy, not only for us, but for everybody. We appreciate that.
Well, thank you. Being down a judge for nearly 4 years in our district has been a significant challenge. Fortunately, Judge Jarboe arrived in September and really hit the ground running. But Judge Bell had been off the case draw since October of 2016, so we had more than 4 years of three of us plus Judge Quist drawing cases, and then Judge Quist chose to, on senior status, to take himself out of the draw. So we were really up against it. I don't insist on yes or no answers. I think those lawyers who have appeared in front of me recognize that I'm willing to give lawyers a lot of running room in terms of their presentations, number one, their answers to questions, and at great risk to my own time, I usually allow the lawyers to continue the oral argument on motions until they're exhausted and don't have anything else to say. But I don't insist on a particular format, and I may interrupt from time to time, but generally speaking, I'm going to give the lawyers the opportunity to make their presentations in support of their client's position.
Thank you, Your Honor. John, do you have any follow-up from that?
Well, let me ask one question about civility, if I may, Your Honor, and that is, most of us have noticed, maybe hearkening back to old school ways, that there is now a tendency to refer to counsel by their names, at least by other counsel, to people by their names, sometimes by their first names, on the record in the court. I wonder what Your Honor's opinion of that practice is and what advice you would have to practitioners in that regard.
I think reference by first name is inappropriate when we're on the record. Our bar here in the Western District they know each other pretty well, and they do have professional relationships, which under normal circumstances outside the courtroom would call for use of first names. But I think use of first names on the record before the court is not appropriate. Referring to opposing counsel or by referring to counsel by a first and last name is totally appropriate, but first names on the record are out of bounds as far as I'm concerned.
Thank you, Judge. And I'll lastly add, I got a message from Judge Yonker, and I'll read it to the group. He just indicated that amplifying Judge Maloney's comments on pandemic process, each judicial officer is making decisions about what to conduct in person and what to conduct by Zoom. The FBA is currently exploring a Zoom program for sometime in January that will update the bar more generally on how the court is handling this. Judge Yonker, for example, will have a civil bench trial involving a sizable tax refund claim starting near the end of January for a week or two. That will be in person. Other matters are by Zoom or in person as the needs of the case present themselves. So that was just an addition to what Judge Maloney had provided. If anyone has any other questions for Judge Maloney, we will address them at the end of the presentation. Those are the ones that I have at this point. I'm going to move on to the next topic. Thank you again, Judge Maloney, for your remarks. I think everybody appreciates it. Now, our next presenter will be Judge Cameron, who's going to talk to us about writing style and writing for the bench. So I will turn it over now to Judge Cameron.
Great. Thank you very much, Jessica. I appreciate that. And Judge Maloney, thank you very much for that very informative information. I think with regard to this information, I think what happens in the trial court and ethics and candor with the court, of course, applies equally to an appellate court. What I'd like to do, rather than just simply take the same information and apply it in an appellate context, I'd like to talk a little bit about two aspects of the Court of Appeals, which is where I work, and your different audiences with regard to who you're writing to. But before doing that, I certainly agree with, we heard some things about the pandemic process and how Zoom has changed our court process. Among those things, I noticed I need to be more careful on my handle on my Zoom. I notice now, just moments ago, that I show up as Will Cameron. Well, I've got a teenager who apparently used my iPad yesterday for a Zoom. So my name is not Will Cameron, it is Tom Cameron, and I'm a judge on the Michigan Court of Appeals. I'm also, previously, I served on the Wayne County criminal bench as well. So I'm going to try to do my best to give you a little take on both the trial court level, but primarily on the Court of Appeals. What I will say first and foremost, I really want to focus in on who your audience is when you file an appeal. And the audience, to a large extent, of course, in the end, it's the judge. But when I was a judge on the Wayne County Circuit Court and a motion was filed, I can tell you that I was the first person to read it. I was the person to research it for the first time, at least with regard from a judicial standpoint. And I wrote the opinion. I was a one-stop shop when it came to evaluating your work that you filed with court. Now, in the Court of Appeals, it's much different, as you can imagine. The Court of Appeals, there are over 5,200 appeals that are filed every year. We've got 26 judges. About 55% of that 5,200 appeals are appeals by right. And the other 45% are appeals by application, where you don't have a judgment or a final order. And I think it's important to differentiate those two because the audience that you're writing to is different depending on whether it's a appeal by right or it's an appeal by an application or an application for right to appeal. So let's talk about applications first. That's that 45%. There are about 2,200 applications to appeal that are filed every year. So when you file your C-10 motion and it's denied, or you're a prosecutor, a defense attorney representing your client in a criminal case, and you file that motion to quash that's not denied, where you don't have a final order, but you have an adverse opinion by the trial court where you feel the trial court has erred, and you file an application. Well, in those cases, of course, it's filed with the clerk's office. And for applications, I think the thought is, and mistaken belief is that for applications, you have these law clerks, an army of law clerks that are anywhere from 1 to 3 years out of law school. They probably graduated in the top 5% of their class, but they don't have a lot of practical experience. Now, that's true that they work here, but when it comes to applications, that's not who you're writing to. Instead, you have what we call commissioners. And commissioners are career people in the Michigan, in the appellate court here in Michigan. And these are folks that oftentimes specialize in a particular area, maybe tax, maybe no fault, maybe criminal. And we have 6 of them. And for these applications that you file from an order that is not final or a judgment that is not final, you have that commissioner summarizing the briefs, summarizing the law, and then making a recommendation to the panel of 3 judges whether we should grant or deny your application. So given the fact that these are folks that are very, very experienced, and knowing you frankly have a lot riding on that recommendation, you're going to want to write that, I think, in a slightly different way. First, I think I'm a big believer that, particularly with applications, you have to realize that around 20%, if it's a civil case that you're asking for leave to appeal, about only 20% of those are granted. Criminal cases, it's a little lower. So the vast majority of applications are denied. Because of that, you really need to cut to the chase. If you have a case that's very fact intensive, you've got 20, 30 depositions, you've got expert witnesses, you're going to have a tough time, I think, generally speaking, to get that application granted. You've got to really lay out in a very concise way how it is that the trial court clearly erred. And if it's a contest of facts, if it's a convoluted set of facts, more likely than not, you're going to get a recommendation from a commissioner that is going to err on the side of deferring and waiting for the trial court or the jury to make a decision. So you need to be aware that for applications for leave to appeal, there's a lot of them, and the vast majority of them are denied, and you really need to cut to the chase to explain. I'm a big believer, and I think after speaking with in anticipation for this presentation, a lot of the commissioners talked about the value in providing an introduction of anywhere from 1 to no more than 2 pages, stating in very clear terms what this case is about, what the law is, and how the trial court clearly erred. And if you can't do that in a way that even a non-lawyer can't understand, you're putting yourself behind the 8 ball. So the other group of appeals are appeals, of course, by right. There's around 2,900 appeals by right that are received. These are civil, criminal, family, juvenile cases, contract disputes, everything really under the sun. And these are handled a little differently. Unlike a commissioner who handles these applications, appeals by right are reviewed initially by those law clerks, anywhere from 1 to 3 years out of law school. Very bright folks providing recommendations about how they think the law that they should look at, and a recommendation. Now, that's not to say we don't look in either an application or appeal by right what you file. We do. But I think this really goes back to what Judge Maloney was talking about with candor to the court and the importance of stating everything that you have in the case. Because if after reviewing your briefs, I conclude that you're not telling us all the facts, or you are not adequately respecting what the contested facts are, I'm going to be more likely to go to a different source to get what the law is or the facts are. So I think that's very important, and particularly by these appeals by right, since they're being reviewed by law clerks, I would spend a little bit more time recognizing that they may not be an expert in no fault. Chances are they're not. And you're going to want to spend a little bit more time not assuming that your first audience, the first level of review, has expertise in that area. So I would be a little bit more, I wouldn't make the assumptions you might be able to make on an application for leave that you would by appeal by right, understanding that you've got folks that have, while very talented, don't have the same level of experience as a commissioner does. So many of the other factors with regard to the actual brief itself are very important as well. I've already told you about the value of an introduction. You've got to remember that in the end, it's the judges who are making the decision, and on a particular any particular case call, which is what we call it, we're hearing 30 cases that are in typically anywhere from 8 to 10 different areas of law. So to the extent you can provide an introduction to really frame the issues so that we can, as we're listening to your oral argument, or as we're trying to remember what, item number 14 was, that it really is a gripping summary of what your case is about, that I can refer back to refresh my memory about the salient facts or the salient law that applies in the case. And just to reiterate what Judge Maloney had said about that you not to omit important facts that are adverse to your opinion, to your position. It's important to tell us the good and the bad. Don't hide it, don't omit it, but explain to us that even in light of that, why your client should still prevail. In the end, you need to provide what I sort of call soft persuasion in your statement of facts. It has to be neutral, but it has to, but I think the best ones that I've read advocate inconspicuously. And then I'm also, the fact that you're dealing with 3 different judges who probably have very different backgrounds. If you have a property dispute or an issue over an easement, I, for one, have a very difficult time talking about the northeast corner of the 42nd plat of this particular site. I mean, I'm trying to visualize that and how this easement cut across and where the water appears. I'm a big fan, and I've noticed more and more the use of visual aids being actually part of the brief or part of the facts. Certainly needs to be part of the lower record. You have to make sure you protect the record and make sure it's admitted. But being able to, a picture says 1,000 words, being able to actually put that in the right case, not every case, but in the right case, particularly what I found when you're talking about property law, easements, that just it causes me to want to go back and use your brief as a reference to make sure that I understand what took place here. So it puts you in a better position. But as I said, you have to make sure it's part of the record. And then just to wrap up, when it comes to argument, the argument section of your brief, don't assume that the judges are experts in a particular area of law. I think all of the judges here are experts, particularly in the area that they practiced in, maybe 15, 20 years. But we all have, no matter who we are, we have our blind areas, our blind spots. And make sure that, and certainly if you've got 3 judges and you've got a no fault case, it's unlikely that all 3 judges are experts and practiced in no fault before they became a judge. So, some of us are experts in the area of your case, some aren't. So don't make the assumptions that I've talked about, particularly when it comes to either the law clerk or for the judge. That's really what I have to say with regard to this. I wanted to make sure that there was time for folks that had any questions, whether it's from the trial court level, the Court of Appeals, pandemic-wise, how the Court of Appeals is handling Zoom, rather than me talking about it. If anybody wants to talk about that, about a month and a half ago, I did the only. I know that sounds like we have a judge or 2 in the panel as well. I also got special permission from SCAO, and I did a recent jury trial, the only jury trial that was in Wayne County Circuit since the pandemic broke. So I'm available for any questions you may have, and how we are handling things here on the Court of Appeals, or how I handled the one case post-COVID in the Wayne County Circuit Court.
Thank you, Judge. So I just have to point out that when you were talking about like the northeast corner of this lot, I got severe PTSD. I externed for a judge in Chicago who handled mortgage and loan foreclosures. And so I had to read the legal descriptions of property and it was awful. So not relevant at all, but I just had to point that out. We do have a couple of questions for you though. One of them is from Brad Glazier. He asks whether or not you have any suggestions on how to change oral argument approach in light of Zoom. So I'll turn that question over to you, Judge.
Is that, so in light of Zoom, how you handle oral argument? We've done a lot. In fact, of course, all of our arguments are by Zoom. So if you ask for oral argument, you will receive oral argument via Zoom. It's not ideal. I think all the judges are, from my experience, have been pretty understanding. It's easy to talk over each other on Zoom, to not know when someone finished and another person begins. That's probably one of the biggest challenges we have, just being patient. When you know you've got 12 cases that you need to get to and you're behind schedule. With regard to that, I mean, oral argument, I think it means different things to different people. I think one of the questions I was supposed to ask was, if knowing now, what would you have changed when you were a practitioner? I think, particularly on the Court of Appeals, I think I overestimated the value of oral argument. Certainly it has value, it's important, but I guess I didn't realize as a practitioner in how many cases the die was cast before I walked into the courtroom. And what that means is that, and I think this is true certainly in the trial court, but particularly where we're not holding hearings in the Court of Appeals, you win or lose on what you write. And so to answer the question, you know, what has changed on the Court of Appeals with Zoom? Not a lot. I've noticed, the one thing I have noticed at first, most people were not doing Zoom. Most people were waiving oral argument, even if they endorsed themselves. But as things have progressed, I've noticed there is, this is just anecdotal on my part, but there has to have been a 20 to 30% increase in the number of people now doing oral argument that in the past would have been waived. I've noticed, I mean, far greater number of people now asking for oral argument and using oral argument in the Court of Appeals than was true in the past. That's, so talking over people and also just the nuts and bolts of oral argument.
Thank you, Judge. We have one other question from Lucas Middleton for you. He's wondering whether you can offer insight into how the court handles motions for immediate consideration. And then secondarily, do you have any advice for effective written advocacy in this context?
Yeah, so immediate consideration, those motions are reviewed by our commissioners. With regard to initially, so they sort of triage those initially. There really needs to be a compelling reason for immediate consideration. But by and large, those are reviewed by our commissioners. I'm trying to think, is there any specific question with regard to immediate consideration that you had, bad experience?
Lucas, if you'd like to unmute yourself and inquire on something specific, you are welcome to do that right now.
Thank you, Judge, for being here and for taking my question. I haven't had a specific bad experience. I was just wondering how that was handled procedurally by the court, which you answered with respect to how they're reviewed. And again, with your thoughts as regards when that procedural avenue may be appropriate.
Okay. All right. Well, thank you.
Thank you, Judge. Does anyone else have any questions for Judge Cameron at this time? And again, we can always follow up at the end. I'm not seeing. Thank you very much. Or maybe somebody just spoke up. Sorry.
Yeah, well, John Allen, I thought I submitted this in writing. I'm sorry if it didn't get through. Your Honor, you mentioned the use of visuals or graphics in briefs. What is your thought on including a timeline of events, like a 1006 summary, but with references in the summary to specific exhibits or deposition testimony that corroborates the dates that are given?
Yeah, I think that's useful. I mean, different people write their briefs in different ways. Some people do it in chronological order in the dates, whether it's through an appendix or a list of different dates. I think that makes a lot of sense. But I can say this, is that I can't tell you the number of times I'm reading a brief and I've got a notepad next to me and I'm writing down these dates. And then I get turned page after page after page. In the end, I realized the dates didn't have anything to do with the real issue on appeal. And I'm saying, why in the world was I, spending so much time and energy on dates when, or that's true with anything. I mean, I always have a notepad next to me as I'm reading the brief. In the end, you should provide, let me back up. One of the better appellate attorneys that has appeared before me, he said that one of the tools he uses to make sure that his facts are relevant facts is that he writes his legal analysis first and then does the facts, which is not the way I've ever operated, because that way it forces him to only include the facts that are relevant to the issue on appeal or issues on appeal. So absolutely, if they are relevant dates, know that I have a notepad next to me and I'm writing them down. But if and I'm sure you don't do this, but I have had situations where I just turn the notepad over and I realize I'm not sure what notes I'm supposed to be taking anymore, because I'm being given facts that are important to the attorney, but not important to me making the right decision. Hope that answers your question.
I think it does, John. Thank you very much, Judge Cameron. I have no other questions for you at this time, so I'm going to move on to Heather Bergman. Ms. Bergman is going to talk specifically on oral argument, so I will turn things over to her at this time.
Thank you, Jennifer. And just as a disclaimer, I've spent most of my, or all of my profession in the appellate arena, but I do want to speak a little bit about oral advocacy, even in the trial court. Apart from your opening and closing statements in a trial, of course, I think that oral argument provides a unique opportunity to dialogue with the court. As Judge Cameron indicated, a lot of times, I guess it would depend on your venue, the court may have already made a decision, whether it be on your motion, on your appeal, or whatnot. But I think that the most important aspect of oral advocacy is to know your case very well, know your facts, and know the law, and to be prepared to respond to questions from the court. Because I think that the most important thing is that you are educating the court and wanting the court to arrive at the correct decision. And I think oftentimes if you're thinking of any kind of pet peeve, that was something that we were asked to consider with regard to the topic that we were assigned, I would say that you have to really consider who your audience is. And again, apart from an opening statement or a closing argument to a jury or a judge in a bench trial, your audience is the court. It's not your client. And oftentimes I see litigants who really want to put on, I guess, a theatrical show for their client. And I think it can be really distasteful. I think it's not very helpful to the court. And I think that when you're looking at oral advocacy, it's really a time for your legal theories and your arguments to be tested by the court. With that said, some courts are not very active as far as asking questions. It might be a straightforward legal issue. And so I think you have to be prepared, of course, to go in with, as Judge Cameron indicated, a summary of the facts and the law, And a lot of times too, if you have multiple issues that you're litigating, you want to focus on maybe the one that's the most contested issue. And I don't know about you, but a lot of times when I'm writing, sometimes it's a struggle to put something in words, written words that you think that could be more easily explained in person. And so I like to use oral argument as the opportunity kind of to expound on the written argument and perhaps explain and give maybe scenarios. But I think you need to be careful not to exceed the content of your written pleadings as well, because then you're kind of catching the bench, I think perhaps off guard. You're maybe presenting a new case that you didn't present in your pleadings. You're presenting a whole new argument that you didn't put in your pleadings. And I think that then you are not being really helpful to the bench, because you're presenting issues that they have not had an opportunity to research and consider before your hearing or your oral argument. And the other thing I wanted to touch on is that you shouldn't read your pleading. I know many judges through my career have, before we have gone up for argument, whether it be on the appellate level, the Court of Appeals, Supreme Court, whatnot, they don't want you to read your pleadings. I think that's very boring. It's a waste of time. Really go in with the idea again that you're there to make yourself available to the court for questions and to, again, do what you can to lead the bench to a correct decision. And you're really wanting to focus again on probably your main points or the most contested issues. And I think too, with regard to questions, kind of overlapping a little bit what has already been discussed by Judge Maloney and Judge Cameron, when you do have questions, something that I've learned through the years, it's okay to say that you don't know the answer. I think it's much better to say that you don't know and would like the opportunity to perhaps further brief the issue. And even sometimes asking the bench to express maybe what their thoughts are, and that can help you formulate maybe an answer to the question. But in the bottom, if you don't have an answer, don't provide an answer that you don't think is or don't know is well rooted in the law. I don't think it's a great idea for your reputation, nor for the success of your case. Another thing I wanted to touch on, and this is a little bit outside of oral advocacy, but I think it's important because a lot of times trial practitioners don't think that the standard of review has anything to do with them. That's often considered just an appellate issue. But I want you to really think about reconsidering that, because you're ultimately wanting to, what happens at the trial level, to stick. And so I think it's helpful. And when I brief in front of our trial bench or file motions or whatnot, I think it's really important to tell your trial judge what the standard of review is, because I think that it helps him or her to create a good record. It helps them to know and what level of deference will be given on appeal. And again, ultimately, you're wanting to not only win at the trial level, but then to have your conviction or your theory held up on appeal. So again, I think that it's important to protect the record, letting your judge know, your legal facts, your legal findings are going to be reviewed for clear error. I think it helps them too to know what kind of record they need to make, what will be sufficient for an appellate court to review. And again, ultimately, I think that it helps your court come to the right decision, which I think is the whole purpose of effective legal writing and oral advocacy. So if you have any questions regarding oral advocacy or writing, I do admit that I've done a lot more writing than I have oral advocacy throughout my 25 years. But if you have any questions regarding either one, I'd be happy to answer them.
Heather, we have a couple of questions. The first one is from Beckett Jones. With written versus oral advocacy, stylistically, do you tend to then provide basic arguments in written advocacy and save the most prudent analogies for oral advocacy?
No, in fact, I think it, and it might be a personal preference, but I think a criticism of mine, and I know that attorneys are very busy. We're all very busy, and we have lots of cases on our dockets. And I think that you do the court a disservice when you provide very bare bones legal argument in writing. I don't think that it gives the bench time to prepare, to respond to the argument. And a lot of times, even on the whether it be the trial level or the Court of Appeals or even the Supreme Court level, we have folks who are reviewing these arguments and preparing the judges to hear them. And so when you just file a very simple, basic motion that kind of just gets your foot in the door, and then you wait for oral argument to really flesh out your claim, I think you take a great risk that the judge may not be ready to respond effectively to your argument.
Yeah, and I think that is kind of what Judge Cameron was saying when he was speaking regarding making sure that your briefs are full of everything that you want the court to know, because the decision is often made before you even get to oral argument. So I think that's consistent from our panelists. The next question is from Tom Murray, and his question is, how do you handle a situation when the judge obviously does not agree with your position? Do you end the argument? Do you finish the argument to make a record?
Well, that kind of goes back as a thought that I actually had when Judge Maloney was presenting with regard to ethics, when he said he doesn't like when parties go at each other. I just had a recent experience in court where the defense attorney on appeal it was very obvious that she didn't agree with what the judge had, the ruling the judge had made. And there was a lot of attitude, and it didn't go well. I wouldn't say I don't think it went well. I know it didn't go well because I could see the reaction from the judge. I think you're really treading on thin ground when you start having an attitude with regard to the court's ruling. I think that you can tactfully respond, and I think that's where oral argument is effective. I do like to think of oral argument as more of a dialogue. I don't think that we should be disrespectful as litigators, but I think that there's clear opportunity to not challenge the court, but perhaps ask a question, and say, would it help if I explained it this way? Or is Your Honor open to any further explanation? Again, I think that it's our opportunity to dialogue with the bench. It's not just a one-way conversation. So I think that it can be done tactfully, but if you are obviously on the losing side and the judge has indicated as much, I think that it would probably be worth your time just to sit down.
Okay, thank you, Heather. Does anyone have other questions for Heather at this time? If not, I'm going to open the door back up to any questions for any of the other panelists. And Judge Maloney, I do have one that came in through my email for you. Let me get back to it. And I'm going to butcher the name of the individual who asked the question. It's Nicholas O'Hain something. Could you please talk about your candor expectations for counsel in ex parte proceedings versus adversarial proceedings?
Ex parte proceedings shouldn't happen too often. I mean, obviously there are circumstances where you're communicating with the judge for one reason or another without other counsel being present. But under the circumstances where it's appropriate, I think there's a heightened goal, if you will, of candor with the court. mean, most of the time when I get ex parte motions, it's in the context of motions for reduction of sentence that pursuant to 5K of the guidelines or something of that nature. But ex parte communications is particularly delicate, and to the extent that they are sanctioned, I think it's real important that under those circumstances that you're giving the judge, 100% of what's happening here without any sort of shade, if you will.
Thank you, Judge. And Ms. Bergman, I'm going to come back to you with another question in follow-up to Beckett's question. If you're wanting to pack your brief with all pertinent information for the judge to review or consider, how do you decide what to say so as not to repeat your brief and oral argument?
Again, I think it depends on your audience. So in the trial level, at the trial court, I typically will highlight my arguments, and it's more for a record, so that the record is complete in the transcript when it goes up on appeal, to make sure that whatever I've orally argued is consistent with my brief again, or my legal pleadings. When you're up at the Court of Appeals or the Supreme Court, again, I think it is to highlight your arguments. And if you don't get any questions, I tend to, and if I just had a Zoom argument in front of the Court of Appeals on Friday, there were no questions from the panel, and I simply, being the appellee in that case, I simply just addressed the part that the appellant had raised. So he chose to focus on one of the 3 issues that were raised on appeal. And because he chose that argument, I responded to that argument and then simply asked the bench if they had any questions regarding the remaining arguments. So I don't think that it's necessary. That's why I think that it's important to have your legal pleadings, your written pleadings, be sufficient, because sometimes you won't always get out everything you want in oral argument. You may have so many questions that you don't get your points across, and you're left with having to completely rely on your written argument. And there may be other times where you have no questions and you don't really see the need to belabor the point by standing in front of the court and using your half hour that you may be given.
Thank you, Ms. Bergman. Judge Cameron, do you have anything that you would add to what Ms. Bergman indicated? No. Okay.
No.
Thank you. And then we have a general question for all of the panelists. Susan Blakely, in an ABA article, recently addressed the power of decency in the legal profession. She talks about name calling, derision, intimidation, bullying, the distortion of truth, an unwillingness to compromise, a lack of caring, and a reluctance to serve others. Have any of our presenters noticed a problem with this?
This is Tom Cameron. I can tell you on the Court of Appeals, I would say with very few exceptions, no. Obviously, there's the rogue pro per person. Family law can get pretty dicey sometimes, particularly when they're pro per, whether they're in the Court of Appeals or in the trial court level. Trial court level in Wayne County Circuit, it could get inappropriately intense sometimes, but I would say at least on the Court of Appeals, it's probably because you're less likely to have a client in the courtroom, and it's more folks that specialize exclusively in appeals. The only other item I can say is that sometimes when it can get personal is sometimes when you have the trial attorney or the person who's handling it, the matter in the trial court level, who's not experienced doing appeals and argues the case as though as though it was a jury, and can get sometimes personal. But I, for one, and my colleagues are pretty quick to get that back into check.
Thank you, Judge Cameron. What about you, Judge Maloney? Anything you'd like to add?
I have not experienced the question used the word bullying. I haven't seen any of that in my course of my time here in the federal court, and I can't really remember any experiences in state court that were particularly difficult. That controlling that, of course, is the trial judge's responsibility, and if it does lapse into bullying of witnesses or things of that nature, then it's up to the trial judge to remedy that situation. But I can't say I've seen an increase in that, because generally speaking, my experience, I haven't had much experience in that at all. Because I think for the most part, lawyers, I have great confidence in the lawyers on our side of the state. I think the practice of law here is significantly different than the anecdotal stories that I hear from other of my colleagues across the Sixth Circuit. I think in a large respect, we're blessed for that. I know as a trial judge, I feel that way. We haven't talked much about trial tactics, trial presentation. Let me give you some bullet point thoughts of things that I think are ones that reoccur. First, opening statement for the plaintiff, or for typically the plaintiff in a civil case, and obviously the government in a criminal case. Opening statement. It's very effective to save some of the good stuff that's going to come into your case. Don't mention it in an opening statement. Leave it, and then leaving the thought in the juror's mind, this lawyer's got a better case than even he told us about on opening statement. Cross-examination of witnesses, and I continue to see this, the urge on cross-examination to just ask one more question. You've done a good job of making your points with the adverse witness. He's at the point where he's on the witness stand, and you've done a good job making your points, but you want to put the nail in the coffin, if you will. Well, a lot of times that last question will give the witness the opportunity to explain what is adverse to your client. If you've done a good job on cross, major points, sometimes the most effective thing to do is to sit down and use what you've accomplished with the witness on oral argument, on closing argument at the end of the case. Lastly, use of electronics. This is the growing trend. I see electronics in virtually every case that I try. First, unless you're an expert using the machine, and I am not, I barely find the on-off button, okay? Unless you're an expert, do not do the electronics yourself. Have your 14-year-old son or daughter come in and help you with that. But don't try to do it. I've seen it multiple times where the lawyer has hurt his or her presentation, and therefore hurt the presentation on behalf of the client, because the lawyer is just fumbling around with the electronics. But use of electronics can be very effective. I think in this day and age, the jurors are looking for it. Helping your presentation in terms of, on the criminal side, if you're arguing on behalf of the defendant, these are the elements of reasonable doubt in this case. And not only are they hearing it, but they're also seeing it. And I've seen lawyers very effectively use electronic communication during the course of their opening and closing arguments. But again, unless you're an expert, don't try to do it yourself. Because you're trying to think of the legal implications of the answers and all that sort of thing, in addition to trying to run the machine. And unless you're an expert, don't do it.
Great points, Judge Maloney. Thank you very much for your insight. Does anyone else have any questions for any of the speakers, or any of the speakers have anything that they want to add? And it doesn't sound like it. Both of the bar associations appreciate all of you speakers coming in to join us. It was extremely helpful, extremely insightful from all of you. We also thank all of the participants. I think we had at one point almost 110 people in watching this. We recorded the presentation, so it will be up on the website for anyone who missed it. But thank you again. We'll go ahead and end the meeting at this time.
Thank you all very much.
Thanks, everyone.